I'd like to reserve 3 minutes for rebuttal. May it please the Court, I'm Bill McKnight, and I represent Brenda Chung in this appeal. Basically, we are appealing the Judge of Compensation Claims order that she entered on December 6th of 2005, where she refused to consider 63.5 hours of time spent by the employee's attorney generating evidence which showed that the employee was entitled to additional indemnity benefits. The litigation ensued in this case with 2 petitions being filed by the employee, the first seeking psychiatric evaluation and treatment, and the second seeking payment of temporary total or temporary partial disability benefits. Ultimately, a verified petition for attorney's fees was filed seeking payment for fees based on 4 things: indemnity, psychiatric evaluation and treatment, payment of medical bills, and also payment of prescriptions. The employer carrier readily conceded that it owed attorney's fees for the payment of the indemnity benefits, but they contested that they owed fees for the value of the psychiatric care, the medical bills, and the prescriptions. The court held its first hearing, which it titled in its order of May 20, 2005. Well, it didn't title it, but it said that the hearing was to do with entitlement. In that hearing, the court reached the conclusion that the employee's attorney was not entitled to be paid attorney's fees for the psychiatric care, for the medical bills, and also for the prescriptions. Thereafter, we went to hearing on November 18th of 2005, and the employee took the position, Judge, we're not going to argue with you about whether or not we're entitled to fees based on the value of the medical care. But we want you to look at the time we spent on obtaining the psychiatric evidence in this case, because it's the psychiatric evidence that got the employee the indemnity.
Well, Mr. McKnight, didn't the Judge of Compensation Claims accept the employer carrier's assertion that they paid temporary indemnity benefits based on psychiatric issues based on Dr. Pena's testimony or opinion and the Rojas case?
Actually, the judge ruled that the 63.5 hours would not be compensable because in her order, which is at page 1169 to 1173 of the record, she said that the employer carrier's expert, Kathleen Hudson, said the 63.5 hours were not compensable.
But the issue was, as I read it, was that rather that the time spent in obtaining Dr. Rawlings' opinion was not time spent in obtaining temporary indemnity benefits because the EC asserted and the JCC agreed that they acted based on Dr. Pena's opinion in the Rojas case.
Well, there's 2 reasons that doesn't hold up under scrutiny. The first is the Rojas decision was issued in November of, I believe it was 2004, and they waited approximately 10 weeks before they paid the indemnity benefits. So the Rojas decision didn't cause them to act. And secondly,
is that such an unreasonable period of time, given the fact that there had to be a motion for rehearing filed, and so is 10 weeks in understanding a new appellate case so long?
Well, that's not the point. The point is that they are liable for attorney's fees when they don't pay benefits within 14 days of the time they're due. And secondly, about Pandia, for them to say, well, we were relying on Pandia, that doesn't hold up either, because when you look at Dr. Pandia's testimony, Dr. Pandia says in his report, I don't believe that her psychiatric conditions are directly related to the industrial accident. So when they rolled over and when they paid their indemnity benefits, they did so based on a record that showed one thing. Dr. Rawlings says causal relationship, aggravation, temporarily and totally disabled. And we have Pandia who says no restrictions, no causal relationship. So they may want to argue that, well, yeah, we did it because of the Rojas decision, but the evidence doesn't show that. Keep in mind, it's real important that when we took the adjuster's deposition on June 5th of 2002, she readily conceded we are questioning whether or not this psychiatric condition is related to the industrial accident. So at the end of the day, when you look at all the evidence, the only thing that happened is the employee's attorney put in 63 and a half hours to get his IME, to get the adjuster to admit that she was going to give psychiatric care. In addition, the employee's attorney obtained a referral from Dr. Garcia, the pain management physician, which she gave to the employer carrier, and then they give the benefits, they give the psychiatric evaluation in August of that year, and Dr. Pandia, although he said the condition was unrelated, in August of that year, he said, look, her global assessment of functioning is 55 or 60.
So your point is that even though the JCC said they accepted the employer carrier's assertion that they paid the indemnity benefits based on Dr. Pandia's testimony or opinion, that there's no competent substantial evidence to support that?
Well, in addition to there being no competent substantial evidence, because Dr. Pandia's report says I don't directly relate to the industrial accident, when we consider the testimony of their own expert, Kathleen Hudson, I asked her to consider the evidence in this case. And when she considered the evidence in this case, she said, the only evidence that I find in here that would support the award of indemnity benefits would be Dr. Pandia's opinion. So even their own expert said, yes, it's what you did that got the employee their benefits. As the court knows from several decisions which are cited in my brief, obviously the award of attorney's fees, as the court said in the city of Riviera Beach, are, you award attorney's fees to an attorney where he gets benefits that had he not been involved in, the employee would not have otherwise gotten. The fact of the matter is, had I not come into this case, had I not filed a petition seeking psychiatric evaluation and treatment, had there not been psychiatric evidence generated that the employee was not at maximum medical improvement, which the employer carrier accepted, this employee never would have been paid the additional indemnity benefits.
Mr. McKnight, didn't she saw the JCC saying that since you didn't go through managed care, that's a bar, and I want to ask you a little something about that managed care program. According to the order, there's a finding that the managed care agreement was in effect on 2003 to 2005. That leads me to conclude that it wasn't in effect at the time you filed your original petition for benefits in 2002. Is that correct?
Well, Your Honor, with all candor, the judge initially ruled that we comply with the managed care arrangement, and then she seemed to change course.
Was there one in? Was it because there was not one in? She ruled that you didn't have to comply in 2002, as I recall. Her first order.
Well, her first order said that we had complied,
right.
And then when we got to this hearing in April of 2005, they went ahead and they re-argued the issue, and the judge said, look, it's not res judicata. I'm going to revisit my decision, and therefore, you don't get your attorney's fees based on the value of the medical care. But the important thing I'd like to bring to the court's attention is really the first step in determining attorney's fees, and that's what happened in April of 2005, is the judge has to say, what's the total basket of goods or benefits that you have obtained for this employee? Now, once the judge knows that, then the judge sits down and does the determination, is a presumptively correct statutory fee going to be what I award in accordance with the Tri-State Motor decision? Or does she say, are there enough factors here to allow me to depart from the guideline fee? Let me suggest that had we prevailed on psychiatric issues, the psychiatric care, and there had been $300,000 worth of psychiatric care, that certainly we would say, look, a guideline fee is what we have to live with. But we went to step one on April 25th of 2005, and the judge said, I'm not going to award you benefits based on the value of medical care. We then go to the hearing in November of 2005, and I say, Judge, fine, medical care is off the plate. But you have to look at the efforts that I put in this case to get the indemnity, which they don't dispute. And when I did, the court said, I'm not going to consider that 63.5 hours, but those were the hours that put the evidence in front of the employer carrier to make them pay the indemnity benefits. I see I'm into my rebuttal time, so I'll stop now. Thank you.
Good afternoon, Your Honors. May it please the Court. My name is John Crotty, and I represent the appellee, Zephyr Haven Nursing Home and Adventist Health System. Your Honors, the issue in this case, as framed by the appellant, are whether or not the TPD benefits flowed from the 63.5 hours of time that were spent litigating a managed care and grievance issue that existed based on the November 9, 2001 petition for benefits. I heard that a question was raised as to whether or not there was a managed care arrangement in effect at the time that petition was filed, and the answer to that question is yes, and it's in the record at 1166.
I was looking at the JCC's order. It said there was a managed care in effect on 2003, and this was in place until 2005. That's what sort of confused me.
Well, yes, Your Honor, but at the top of 1166, the very first couple of lines, it indicates that the employer carrier had a managed care arrangement in place during the relevant times herein. And there was evidence that the carrier had managed care in 2001, 2002, up until January of 2005.
Without a managed care agreement and all the things that happened, has happened in this case, other than there being a managed care plan in place, would Mr. McKnight's client be entitled to attorney's fees?
With respect to the TPD claim or with respect to...
So what are you claiming right now? The only thing I want you to do is take the managed care out of this factual mix here and tell me whether or not he'd be entitled to attorney's fees in your view.
I believe the answer would be no. And if the court would like, I can elaborate further.
I'd like to know, because it seems like your client capitulated and paid the psychiatric fees after earlier taking the position it was pre-existing. Isn't that correct?
No, Your Honor. The claimant did have a pre-existing psychiatric problem.
Well, you didn't. He had to go to file a petition for benefits to get them paid, didn't he?
The TPD benefits? Yes, Your Honor.
Yeah.
And that is why...
And that includes the psychiatric benefits, right?
No, Your Honor.
Did you pay any psychiatric benefits?
We did provide psychiatric treatment.
When?
After a referral was obtained from the treating doctor, that referral was sent to the carrier, actually to my office at the end of May. It was then forwarded to the adjuster. The medical care coordinator reviewed it, and on June 5th, about 1 week after the carrier received the referral, the carrier authorized psychiatric treatment. The first available appointment was in August.
Was there ever a time in this proceeding that the carrier denied psychiatric benefits?
Not after a referral was obtained, Your Honor. I think that Your Honor is asking why didn't the carrier authorize treatment when the petition was filed?
Benefits were secured for this claimant because of Mr. McKnight's efforts. And it wouldn't have been paid had he not done it. Is that correct?
I do not agree with that, Your Honor.
All right. Well, tell me why you don't.
Thank you. Your Honor, we spent 63 and a half hours, that is at issue here, litigating over the failure, or actually the refusal of the claimant to follow the managed care procedures. A petition for benefits was filed in November, but up until that time there had been no referral to a psychiatrist. And in the depositions of the doctors that were taken, Dr. Delgado, Dr. Shim, Dr. Garcia, none of them had any observations of any psychiatric problems. The claimant did not get a referral. The carrier did not receive a referral. And more germane to the point of the managed care issues here, before the petition for benefits was filed, there was no initial request for service. There was no letter, form, anything that was sent to the carrier from the claimant asking for psychiatric treatment, and there was no grievance filed. And so when the petition for benefits was received, the carrier's response was to the claimant, you have to follow the managed care procedures, get a referral. And if the treatment is denied after the referral, you can file a grievance. But none of that happened, and we spent 63 and a half hours fighting over the refusal of the claimant to follow the grievance procedures. And as noted in one of the judge's orders, it was the claimant's position that the carrier didn't even have a managed care arrangement in effect.
But on 4/24/02, the JCC ruled that you didn't have to follow the managed care procedure, didn't it?
In April of 2002, we had a hearing on the carrier's motion to dismiss.
For failure to follow the managed care procedure.
Right, and in that order, the judge held that the claimant did file a request for assistance, and that was sent to the EAO office. A copy was not sent directly to the carrier, but the carrier ultimately did receive one from the EAO office.
And after that, the claimant's attorney secured the information that ultimately resulted in your client paying the psychiatric claim. Is that correct?
The carrier's attorney got his hands on a referral for psychiatric treatment from Dr. Garcia, and he mailed that to me. And he mailed it at the end of May, while we're in the midst of this litigation over the grievance issues. And the carrier, again, within 1 week, authorized psychiatric treatment.
Well, Mr. Crowley, after the JCC ruled that the managed care was not a bar to his proceeding, you weren't litigating at that point over the managed care, I don't believe, were you?
Yes, sir, we were. We had a trial set for June 19, 2002, and even though we had the judge's order denying our motion to dismiss, it was certainly my intent to continue with our defenses because it was clear in our view, at least, that the claimant had not exhausted the grievance process, that simply sending an RFA did not satisfy the Florida Administrative Code positions on exhausting the grievance process. And ultimately, the judge of compensation claims did agree with our arguments.
About 3 years later.
3 years later, Your Honor. Yeah. But I was going to raise those arguments at the trial in June, except the trial was canceled because the treatment had been authorized.
You stipulated as to the disposition of the claim at that time, didn't you?
Well, the claimant's attorney dismissed the petition, or actually canceled the trial, because the psychiatric evaluation had been authorized by the carrier. I think this situation is somewhat analogous to the case of Wilmot. Wilmot versus Precision Broach, which is at 815 Southern 2nd, 755, where this court denied attorney's fees to a claimant's attorney based on a PTD claim, where the court held that the carrier accepted the claimant as PTD not based on the attorney's efforts, but based on medical opinion from a doctor. And frankly, Your Honors, that is what happened in this case. We spent 63 hours based upon the claimant's rejection of the managed care procedures, but then once the claimant did follow those procedures, once the claimant got us a referral, within 1 week, the psychiatric treatment was authorized. And I believe the judge of compensation claims took those factors into consideration in denying the attorney's fees because that time spent litigating the managed care issues really was not something that was connected to the TPD claim. It was all related to the November 2001 petition.
Mr. Crowley, was there ever a time that the carrier took the position that psychiatric fees were not appropriate because they were pre-existing?
No, sir.
Okay.
Your Honors, there was an assertion that Dr. Pandya did not find that Mrs. Jung's psychiatric condition was causally related to anything in this case, and I would refer the court to page 848 of the record, which is one of the pages from Dr. Pandya's report, in which he states that there is a causal relationship between Mrs. Jung's psychiatric problems and her industrial accident, although he does note that her bipolar disorder was not directly related to the accident. So when the carrier later determined to pay TPD benefits, it was not based upon Dr. Rawlings' IME report, but it was based on Dr. Pandya's findings and Dr. Pandya was an authorized treating doctor.
But he said there was a causal relationship, if my memory's right, but that her psychiatric illness is not caused by the accident.
It is a little confusing, but to the extent he found that there was some causal relationship between her psychiatric difficulties, which is kind of a broader concept, as opposed to her bipolar disorder, a specific...
Which is what the illness was that he was referring to there, was her bipolar disorder, as opposed to a different psychiatric problem? That's why I was a little confused by
Yes, Your Honor.
language.
Mrs. Jung did have a pre-existing bipolar disorder, but if I'm not mistaken, the doctors in this case have also treated her for anxiety and depression flowing from her chronic pain complaints. Your Honor, am I out of time?
Your time has concluded.
I'm sorry?
Your time has concluded.
Okay. Thank you, Your Honor.
Mr. McKnight, you got about 11 seconds. We'll be a little more generous than that. We'll give you additional minutes so you can.
Thank you, Your Honors. Simply put, I would direct the court to page 884. This is my March 8, 2002 correspondence to the employer carrier. This will serve as the employee's demand that you set up a psychiatric IME with Dr. Joseph Rawlings. Since the employee has a petition for indemnity pending, she is not confined to any managed care arrangement process that you allege that you have. In accordance with the court's earlier decisions regarding IMEs, an employee could only get an IME from a doctor within the managed care arrangement process if medical was only being litigated. But it's the Wiggins decision. If the employee is seeking temporary total or temporary partial disability benefits, the employee can go outside of the managed care arrangement. This letter unequivocally says that in March of 2002, the employee was seeking indemnity benefits and was seeking it through the IME testimony of Dr. Rawlings, which the employee ultimately obtained. And for that reason, we believe the 63 and a half hours should be included. Thank you.
Was there ever a pre-existing defense raised?
Sorry?
Was there ever an argument that the psychiatric condition pre-existed the industrial accident?
Yes, the adjuster's deposition was taken on June 5th. I'm now at page 778. Questions by the employer carrier's attorney to the adjuster. They're asking, what did the adjuster discuss with the employee? And the adjuster relates the employee had told them about pre-existing bipolar condition. And from that, it's pretty reasonable to conclude that's why they were holding off on awarding or providing psychiatric care, which ultimately, when we got it,
Thank you, counsel. That concludes our cases for the week. We're adjourned.